Not that I'm aware of.
I'm gonna forward this to you. If you can just tell her maybe she wants to start next week, but Friday, if she can start out tomorrow, you get ready to sign it.
Yep.
Um, all right, let me just check this. All right, this is docket 23845FH and 23842FH. People of the state of Michigan versus Rashawn Thomas II. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Thomas, who's standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
All right, thank you. And have you had enough time to talk with your attorney?
Yes.
I have this as a plea hearing, however, I do not have any paperwork on behalf of the people. Are we proceeding that way, or Mr. Goodrich, do you want to jump in?
Your Honor, the people have offered a plea offer. There was long conversations with both me and Attorney Goodrich. And the people ultimately offered a plea agreement to count 3 felonious assault and an added count 9 of home invasion second. The max for the felonious assault would be 4 years. The max for the home invasion second would be 15 years. Upon successful plea and sentence, count 1, home invasion of the first degree. Count 2, 4, 6, and 8, the felony firearm charges. Count 5, felonious assault. Count 7, possession of a firearm by a felon. And the habitual offender second status would be dismissed. 23-845-FH would also be dismissed in its entirety. And there would be an agreement for a fixed minimum sentence of 43 months to the Michigan Department of Corrections. There have been talks back and forth between me and Mr. Goodrich, and it sounds as though Mr. Thomas does not wish to accept that plea offer. If Mr. Thomas were to go to trial, I've had a chance to run the sentencing guidelines on this case. If he is found guilty of the charges as they are, I have the guidelines at 78 to 162 months, plus the additional 24 months that would run consecutive under the felony firearm charges. For the plea offer that I have given, there is a guideline range of 43 to 86 months.
Is that full, fair, accurate, and complete, Mr. Goodrich?
Yes, that is the offer that has been conveyed to Mr. Thomas. Mr. Thomas at this time would like to decline that offer, and speaking with him, Your Honor, he would like to be able to represent himself in order to file some motions in this case and proceed while representing himself, Your Honor.
Sir, you would like to, first of all, the offer that was stated, that's full, fair, accurate, and complete?
Yes, ma'am.
Okay, that's different than the other ones I had written down prior, so, and you are not interested in that, is that correct? Did anyone force, threaten, or coerce you to make this decision?
No,
Did
ma'am.
anyone promise you anything that caused you to make this decision?
No, ma'am.
All right, and you no longer want Mr. Goodrich to represent you?
No, ma'am.
And why is that?
So I have some arguments I want to make.
What are, you have arguments you want to make?
Yes.
Okay, and did you get a law degree while you were in the lockup?
You said what?
Did you get a law degree while you were in lockup?
No, ma'am.
Okay, so tell me about this
By
motion.
counsel.
Sir, I know, but I know Mr. Goodrich a very, very long time. I don't know anything about the conversations you've had, but I have seen a lot of plea agreements, and I'm concerned, first of all, about what the motions are. Second, this is a plea agreement that's so good I might not even take it. Because, I mean, you've been in a long time. How long has he been in?
I believe it's at 31 months, Your Honor.
Okay, so 31 months minus the 43, you have about another year if you took the plea. And it wouldn't even be a year in MDOC because it'll be probably 7 or 8 months by the time you get the pre-sentence investigation done and all of that. If we go to trial, and it looks to me like, based on the preliminary exam transcript, that there may very well be a likelihood of success. We'll talk about that in a moment, but the guidelines, what did you say, 78 to 162 months, that's what I've written down, is that right?
Correct, Your Honor, plus the additional 24 consecutive for the felony firearm.
So that's somewhere, my math isn't so good, but that's somewhere on the minimum of 8.5 to 15 years. If I don't know anything about your case really. If you were found guilty, with the home invasion first degree is punishable by approximately 30 years. On the minimum, it might be reasonable to give you 15 years plus the 2 years, which would be 17 years. Even if I look at the low end of the guidelines, that's 8.5 years plus 2 years, so that's what? 12 years or something, it's 8.5, 10 and a half years. Minus the 2 years you've done, it's still a lot of time. And even if you appealed, you'd be out. If you took the plea deal, you'd be out before the appeal was probably even read by the Court of Appeals. I'm not understanding unless you have a really good defense. So that leads me to what motions.
Quash the bind over, without bound over no physical circumstantial evidence,
Okay,
just off statements alone.
okay. Well, I'm sorry, but I have the transcript. It was put in here so over the 2 years that you've been in for various reasons, I suppose, but let me look. Have you read the transcript? I mean, you were there at the preliminary exam, right?
Yes.
And there's a couple of eyewitnesses, right? And one of them is, let me see if I can find her name. It appears someone who knows you pretty well, Ms. Mays. Do you know Elizabeth Mays?
Yes.
So her eyewitness testimony is evidence. And she says, under direct examination, and so you were able to see his face? Answer, yes. Did you recognize him? Answer, yes. How did you recognize him? I have a longtime friendship with his girlfriend and him for about 5 years. I've known him for a very long time. And it's more of like immediately when we caught eye contact, my mouth said before my mind could even like get everything around it. I just immediately said, Ray, why are you like, if it's because of Anna, I will leave her alone. And then he took off and left. Okay, so we are going to leave that and come back. Then it goes through how she recognized you. And what was his name? Ray Sean. We call him Ray though. Would you recognize him if you saw him today? Yeah. Is he present in the courtroom? Yes. Okay. Where is he located? He's off to the right in a blue button-up. Okay. Witness identified you, sir, not somebody else, you. And it goes on to say that you were in the apartment, and that goes to the elements of home invasion first degree. You were not invited. And then we have a second witness as well. So I sat in district court as a district court judge, and it's probable cause to believe a crime was committed, probable cause that defendant committed the crime. Just on that one witness alone, I would have bound it over. And that tells me that there is a reasonable likelihood of conviction, and I will not quash the bind over. Mr. Goodrich can write me a brief that's so high, it lifts him 8 feet in the air. based on the transcript, the judge here, Stacia Buchanan, did not abuse her discretion. And there could be a conclusion from the evidence in here that you are the person who caused these crimes. So quashing the bind over, you can do it yourself, you can do it through Mr. Goodrich or any other attorney I can appoint. And the answer is that it will be denied, just based on my reading of the preliminary exam transcript, which is what I would have to do. What's your next issue that he won't file? Or is that it?
Bro, I don't care what allegations a person makes. I don't care what this person says. I didn't do it. There's no evidence or nothing that proves I did
She is
anything.
the evidence, sir. I don't care if you go to the Department of Corrections. If you want to go to the Department of Corrections, we're
I
gonna go to
don't want to
jury
take a
trial.
plea.
You don't have to take a plea. We
All
can
right,
get
so
jury.
let's move forward from this.
Okay, so let me make this very clear to you. This is a final pretrial conference. The offer will go away today. We're gonna work toward trial, which means if you interrupt me, we'll start with contempt and I'll see you in 93 days.
I don't care.
93 days. You want to have that attitude in this court? Mr. Goodrich, you're relieved. He can represent himself. And we're going to proceed to get a trial date. We're done. That trial date will be after the 93 days, which will give him time to prepare. This delay is on him, and we will proceed to a jury trial. You got your wish. Thank you. Next matter.
Your Honor, the next matter is going to be suppressed. We would need to clear the courtroom.
Thank you. Anybody not related to this next case, please step out in the hall. We'll come get you in a few moments. Hello, how are you? Good to see you. I know it's always
Say hi to my dear friend Gina. Hi Judge, how are you?
good. How are you?
Doing good. That little probation violation, I don't know what this is, but. Oh, what
You
is
just
this?
missed our last hearing. You should have been here.
Foreman said I had to go talk to him on the home.
Oh, well, it's all Foreman's fault. Mr. Foreman, do I have a case with you? Is that supposed to be a little while ago?
Yes, Judge, but I can wait,
Okay.
obviously.
It's a motion here, yes.
Yes.
He would like to go before me, and I said that's fair, because his was at 1 and mine's at 2.
Okay.
So we'll let him do that, right?
Thank you, Judge.
It's gonna be, I apologize,
Are we
Shalom.
doing?
Okay, gotcha.
I apologize if I mispronounced that. Defendant is not here, Your Honor.
We'll wait his presence if permitted by the court, Judge.
Okay. This is the people of the state of Michigan versus Ricky Bernard Hubert Jr., docket 254588FH. Counsel, your appearance.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor, Jonathan Foreman, Office of Public Defender, here on behalf of Mr. Hubbard here today. He had some confusion regarding the dates where the defense is waiving his presence. I've discussed that with him, and he's comfortable proceeding if the court will permit it.
That's fine. You may proceed at the podium with your motion to suppress and dismiss.
Thank you, Judge. So Judge, I know that the court's familiar with the briefing, so I'm not going to rehash things too much. But basically, we're here on a Fourth Amendment violation. I raised a number of issues in my brief. I primarily want to focus on issues 1 and issue 3, which is the open alcohol, or more specifically, the lack of open alcohol, as well as the pretext to stop here. So what we have in this case, Judge, is it all comes down to basically the finding of a firearm. And the firearm is found based entirely on a pretext stop. The officers admitted at the preliminary examination that was conducted by Mr. Palmer, who was with my office at that time, that they wanted to see what was in my client's bag. And so they followed the car that my client got in until they think they found something. We thanked them for their honesty, but they basically admitted, yes, we were following him because we were waiting for them to commit a traffic infraction, because we wanted to see what was in his bag. We were looking for a reason to get into his bag. I'm of the opinion that that violates the state constitution for reasons I get into.
Let's stop you there, because just saying that, doesn't that violate the Constitution on behalf of the people? I mean, they basically admitted they're on a fishing expedition. That's not allowed.
Your Honor, they were searching for the defendant because they had found, they had believed, based off the training experience of the officer that had seen the bag, officer.
Is this the alcohol? But that bottle was dry, right?
No. We're talking about the bag itself that the defendant had, that the gun was inside. So they were outside of the liquor store. They saw the defendant's bag, and based on the training experience of the officer, I believe it's Officer Backery, he believed that that bag had a firearm inside of it. So they had informed everyone, we believe there's a firearm inside of that bag, which is when officers started looking at that vehicle and then saw that there was a lack of insurance inside of that vehicle. And that is why they ultimately pulled the vehicle over. This was not due to no suspicion whatsoever, Your Honor. As the case that the defense even cited, sits the Department of State Police. It states that the government cannot detain the public without any level of suspicion whatsoever. But Your Honor, there was a lack of insurance on that vehicle, and they had started approaching that vehicle and following that vehicle due to what they believed to be a gun inside of that bag based off their training and experience.
Okay, got it. So let's start from there. So no insurance, which gives them the cause to stop, and then they have this vision of something heavy in the bag and believe it's a gun. So that's not probable cause?
So the sequence,
suspicion?
the sequence of events here, Judge, is they see my client leaving the store, get into a vehicle. They think there's something in the bag, but they admit on cross-examination, at preliminary examination, that they do not have probable cause to stop based on that. They do not have probable cause to get into the bag itself, despite it being in a vehicle. So they admit that. So
Okay.
I think that's relevant here.
Okay, so let's go to the next step. What about the insurance?
The insurance would give them permission to do a vehicle stop under REN, but I'm arguing under the state constitution that we have to go back before that. That if the officers are following somebody until they commit a minor traffic infraction, that's not permissible. And I don't want to get too bogged down in that, but that's the crux of my argument on the pretext stop, Judge.
Okay.
But I think the alcohol is what's more important. And as you acknowledged, Judge, it was dry. And if there's no alcohol in the shooter bottle, which is what we're talking about here, or in my opinion, even if there's remnants of alcohol, like the drippings, the drops at the end of the bottle that you can't get out, then when you're drinking, then that's not open alcohol, because that is not alcoholic liquor in a container. And that's and that's what requires to violate the open alcohol or statute. And if a person has not violated the open alcohol statute, if this shooter bottle does not get them if the shooter bottle does not contain alcohol in it, then they can't get into the car for the rest of their search. And that's my position here, is that the bottle, we have the pictures of it that I provided to the court. I think the most persuasive one, at least in my view, is what occurred when the officers dumped the alcohol out of the bottles. There was the big bottle with the tequila in it that the officer found after he entered the car, so it could not be the reason for probable cause, which the people can see. And that gets opened and dumped. The small Seagram's bottle, it's vodka, gin, whatever, the clear liquid bottle does not get opened, does not get dumped. And why wouldn't it get dumped? Because there's nothing in it. There's nothing to dump out of it. And so if there's no alcohol in the bottle, it's not a violation of the open alcohol ordinance or statute, excuse me. And if it's not a violation of the open alcohol statute, it doesn't give the probable cause to get into the rest of the car.
Well, and everybody who's returning a beer bottle would then have to be cited and our prisons would be full, or jails.
Precisely, Judge, I think that's exactly it. You know, we are a state that allows returnables, things like that. I'm not saying that's what my client or that the driver was doing here, but I think it sets up that argument.
Right.
That if you're putting your returnables in your back seat, the police just sit outside of Meyer and just stop everyone coming up and say, open alcohol for everyone. Everyone's a misdemeanor. That can't be how that law is interpreted. So I'm happy to answer any questions the court has. I think the court understands the crux of my argument, and I'll leave it there.
Thank you. Response?
Yes, Your Honor. Now, I believe we fully has dealt with the traffic stop issue, so I'm not going to argue anything more about that. In regards to the actual probable cause, under the plain view doctrine, as you know, Your Honor, it states that if the officer is in a lawful position in which they can view the item and the item's incriminating character is immediately apparent, then it can be seized. And Your Honor, I mentioned this in my police report, or in my response, but just so it is pulled up as well. If you see at around 9:17, I have it 9:17 right now. If you can look at around 9:20, both bottles are going to be held up in the top left corner. You can actually see alcohol swishing around inside of this shooter bottle so the bottle will be tilted. I'll play it. And it's at 9:17. And if you look at the bottle, and I know it's a little bit hard to see with the glare, but if you actually look at the corner that is next to the officer's pinky finger, you can actually see some alcohol swish inside of the shooter bottle at the time.
No, exactly, that's why I'm trying not to waste your time.
You can see the alcohol swishing in that bottom corner. Additionally, Your Honor, while I want to bring up defense's argument in regards to the open beer bottles being transferred. The law specifically states, Your Honor, that it's within the passenger area of the vehicle. So within the control of the driver. Typically, when people are bringing back their returnables, they're going in their trunk. They're going in a place that's not accessible to the driver. This is a shooter that has alcohol in it, Your Honor, that is right next to the driver. And additionally, Your Honor.
So that was in the front seat, not in the back?
Correct, that was in the front seat. That was it. It appears to be from when the officer pulled it out inside of the pocket next to the driver's seat. So it was right next to him, and it was right next to this bottle that he could not get a clear look at as to whether it was opened or not. He believed it was open, but he did not have, he believed under the plain view search that it was immediately apparent. But based off of that shooter that had alcohol in it, and then looking at the overall circumstances, Your Honor, he had probable cause to search that vehicle. Under the automobile exception, Your Honor, that's stated in People v. Sinistai 184 Mish App 191, it states that a police officer who had probable cause to believe there is contraband somewhere in the automobile may search the entire vehicle and any container found within without first obtaining a warrant. And it states that probable cause exists when the facts and circumstances warrant a person of reasonable prudence to believe that the evidence of a crime or contraband sought is in a stated place. So, Your Honor, after he had seen that shooter and saw the little bit of alcohol inside of that shooter, he had the facts and circumstances viewed in the totality. They had just driven away from an alcohol store. They had found the shooter. They had seen a bottle that they had believed, and they were not sure whether it was open, but they believed that it was open. That resulted in them having the probable cause to get that bottle, see that bottle, and then the probable cause to extend that search to the bag as that bag was seen just coming out of the liquor store, Your Honor. So I believe there is probable cause for all the search in this matter, and I would ask that you dismiss this motion to suppress.
Final word, your motion.
Just a couple things, Judge. I think the prosecutor misstates how the plain view exception applies here. In order for the officer, the officer sees this shooter bottle in the side pocket of the door. The officer would have to know at the time that he reaches to pick up that bottle that there's alcohol in that bottle in order to seize it, because otherwise he is intruding on a protected area without probable cause. And the plain view exception requires that the incriminating nature of the evidence be immediately apparent. There is nothing in this record to support that the officer knew when he reached into the car that even assuming that the bottle did have alcohol in it, there is nothing to support a finding that the officer knew when he reached to pick up that bottle and reached into the protected area of the vehicle, that he knew that there was alcohol in that bottle. So the prosecutor is arguing facts that are not in the evidence here today to justify this search.
Well, let me just stop you there. So plain view, if the alcohol's in the front seat, which it should not be. If it was in the back seat, it's a different argument. This alcohol was in the front seat, right?
The shooter bottle?
Yes.
What was in the front, was in the side door. But my argument, Judge, is twofold. Well, I don't want to.
Go ahead.
My argument is twofold. One is that there's no alcohol in that bottle.
Okay, then argue this. This is sort of textbook law school. Officers can make a mistake, but ultimately be right or wrong. And the law does give them some grace for being human. And how does that play in here, or do you think it doesn't?
I think it doesn't. If you're referring to the good faith exception, Judge.
Yes.
The good faith exception applies when an officer is relying on a warrant, or is relying on a statute, or is relying on some police database. It doesn't rely on an officer. It doesn't allow for an officer to make a mistake and then say, oops, I was wrong. I get the evidence in anyway.
But they've got the plain view. So in good faith, he sees alcohol, says it shouldn't be in the front, and then proceeds to check it out for safety of the public, right?
But not if it's an open bottle, not if it's an empty bottle, Judge. If it's an empty bottle, there's no actual alcohol in there to violate.
But he doesn't know if there's an empty bottle. He only sees the top and then discovers another bottle.
And that's precisely the point, Judge. He doesn't know if it's an empty bottle. And if he doesn't know that it's an empty bottle, then the incriminating nature of the evidence is not immediately apparent. If it's a dry bottle, if it's an empty bottle, then it's not contraband. It's not evidence of a crime. And therefore, he can't reach in to get it because and violate the Fourth Amendment, because it violates the Fourth Amendment when he does that. And he can't rely on his own good faith on a good faith mistake that he made in order to justify a Fourth Amendment intrusion. As it relates to the bottle, Judge, we provided pictures and screenshots that are provided by the prosecutor's office, or the picture was provided by the prosecutor's office, that shows that the bottle is empty. The prosecutor is asking you to rely on some trick of light to say, hey, look, there's liquid in here. But there's not. We have an attached exhibit that shows that there's no alcohol in that shooter bottle. So for all those reasons, Judge, I would ask that you grant our motion, and happy to answer any more questions you might have.
So what about under the open container law, although it was virtually empty, if there's a little bit of alcohol, doesn't MCL 436.1915 say the presence of a container that contains any amount, so it could be a drop of alcoholic liquor is a violation? And doesn't that apply here?
If I can just have one moment, Judge.
You may.
You said MCL 436.1519?
1915.
1915. I see that saying that it shall not be consumed on the public highways, Judge. Is that what you're referring to?
Well, it's that the presence of that container, the presence of a container in the front part of the vehicle is a violation, any amount. It doesn't specify as to, I mean, it could be a few drops and that would be a violation. You don't read it that way?
I don't read 257-624A that way, Judge. I'm not seeing, and I apologize,
That's
I
okay.
wasn't familiar with
Okay.
this
And
statute.
then what about the automobile exception that there's probable cause to believe a crime was committed, and that was open container because they saw that. And then it allows a warrantless search of every part of the vehicle and its contents.
So I have two responses to that, Judge. First is that if there was an open container that definitively contained more than remnants of alcohol, then yes, that would violate the open alcohol in a vehicle, MCL 257.624A. And that would, under the prosecutor's argument, allow for a search of the vehicle for other bottles of open alcohol or other containers of open alcohol. I dispute that in part in my second argument under the state constitution, as well as under the federal constitution based on Meade, though I understand that that's a consent search case. I think the same principles apply here, that where my client is not implicated in the open alcohol in any way because my client's on the passenger, isn't the passenger. And all the open alcohol is, any open alcohol that's there is clearly on the driver's side. I don't believe that would give the police the authority to go into my client's bag because he retains possessory interests and privacy interests in his bag. So that's my first point there, Judge. My second point is that sorry, it slipped my mind. But regardless, Judge, I would argue that there wasn't any alcohol in the bottle. And it's the people's verdict to show that there was alcohol in the bottle. If it's an empty bottle, no matter where it is in the car, under my position is, no matter where an empty bottle is in the car, does not give rise to allow for a search.
And what about the officer's training that he believed that there was a gun in the bag?
They acknowledged at the preliminary examination that they did not have probable cause to search the bag.
Okay. And are you saying that it was not reasonable then to also check to see if there was insurance on the vehicle? That was a pretext?
My argument, Judge, is that the existence of a pretext stop where it's admitted by the officers that they were looking for a reason to pull this person over is a violation of the state constitution.
Counsel, response?
Yes, Your Honor. In regards to that argument, defense has not listed any statutes or case law to show that is illegal, Your Honor. As I had stated, this was not just a mere search of the vehicle because they felt like it, Your Honor. There was no insurance done. They had seen the defendant run they saw the driver run a red light. They had seen so the officer that pulled him over was not the one that saw the bag, but there was an officer that informed the people that started following the defendant's vehicle that they believed that there was a gun in that bag based off of their training and experience. In regards to the alcohol, Your Honor, that question was not asked at preliminary examination, whether the officer saw alcohol inside of that shooter bottle or not. I will say he says so in the police report, and if we wish to have an evidentiary hearing where I bring in that officer to make that statement, I can do so, Your Honor. But you can also see in that piece of video that I had shown that there was alcohol in the vehicle. The defense says it's a trick of the eye, However, Your Honor, in that photo itself that was sent, the flashlight is so bright, it's hard to even see what's inside of the bottle in the first place, Your Honor. So I believe if we need to, I can call in Trooper Morgan and have him testify as to whether he believed there was alcohol inside of that shooter bottle or not. But I believe you can see it pretty clearly in that video that I had just played for Your Honor. In regards to the search of the defendant's bag after the alcohol was found inside of the vehicle, Your Honor, I had listed in my response an unreported case, People v. Parad, 2023 Westlaw 599-2060, with the Michigan Court of Appeals from 2023. That was a very similar case where, once again, there was a firearm that was found in a vehicle during an open alcohol container search. And the Court of Appeals found that the open alcohol container alone gave the police probable cause to search, stating, quote, "After observing the suspected open liquor bottle, the police also had probable cause to suspect that the passenger compartment might contain additional contraband, such as other open alcohol containers, particularly in those areas of the compartment within the defendant's reach." Your Honor, the bag was found in the the front passenger seat, which would have been within the driver's reach in regards to whether there may be open alcohol containers. So despite that, the fact that the bag was the defendant's, the driver, Your Honor, still had reach for that bag. So I believe that under the exception for the automobile exception, this case is on point and makes it very clear that the officers could access the bag and find the firearm.
Final word?
Thank you, Judge. I'm not focusing too much on the search of the bag as related to the automobile exception today. I'd ask the court to focus more, I'm not waiving that argument by any means, I'm not conceding it, but I think I have stronger arguments elsewhere. Specifically, that there was no alcohol that was there was no open container of alcohol that was in plain view at the time that the officer began his search. And if there was no open alcohol that was in plain view at the time that the officer began his search of the vehicle, then everything that followed must fall. And so with that, I'm asking the court and I should remind, and I know the court knows this, but it's the people's burden to present facts to show that the officer's actions were justified.
All right,
And I don't think they've done so today. Thank you, Judge.
all right, thank you. If this alcohol shooter bottle was brought to this court, would it have alcohol in it, or did the officers dump it out, or simply was there none? Choice A, B, or C?
I say choice C, Judge, but of course I'm going to say that. And I'll leave it there.
On behalf of the people, do you know?
Your Honor, I'm looking right now to see if that bottle was taken into evidence. Give me one moment. So, Your Honor, oh, this is the wrong report. One second. I apologize. There's 2 reports in this case. Your Honor, it does not look as though the shooter bottle was seized. Like I said, I can bring in Trooper Morgan, who
And
saw that.
that's why I asked counsel, because I think there is an issue there. Although there is a claim of the vehicle running a red light, but I think you're disputing that. Is that correct as well?
I am disputing that judgment regardless, I want to give them
Right.
research.
Right, so, well, it's running the red light, no insurance, what's visible from what they can see, so, since we don't have the bottle, I don't know if they dumped it out, I don't know, I'm not going to guess, so we're gonna have an evidentiary hearing in accordance with the, case law, and, we'll bring in the, whatever, testimony and evidence you have, and we'll set that up in the next couple weeks.
Thank you, Judge. Should we get a date from your staff?
Please, I'd give you one, but you're gonna yell at me because my docket's so congested that they'll find you a time.
Understood. We'll go back right now. and get that,
Thank
Your
you.
Honor. We're gonna do Carper next.
Okay,
Your Honor, can, brother counsel, my approach before we start? Thank you.
Yes.
Yeah, you had a huge file and you had written it, I can't hear it. If he has picked up new criminal activity, defense is gonna be asked, oh, there it is. Defense is gonna be asking, to set it out. I would like to have the hearing, I believe I can proceed, proving the case to the standards required by a probation violation. He does not want to do that. My second, thought process. Why?
This thing, to see what may have to be part of the case of my understanding the new charges is already retained an attorney. I'm simply trying to act in abundance of caution. We'll see how that might be proceeded before we proceed with it.
So my problem does that oftentimes we have defendants who are very violent and they pick up 5% is not probation. And I find that the basis is not aiming to protect their rights. But the problem is that we leave a case a guy that's very dangerous on probation with no answers. And to me, that's unacceptable. When I have the victim, I talked to this morning, she was a zero person, I have all the text messages. You know, so let me just ask. I get reasons. Is this the?
Yes.
Yes.
and is there a new case on this?
Yes,
Yeah.
yeah.
So he testifies that the thief is constitutional right.
But he doesn't have to testify.
You
Like-
would have a right to testify. if
He
you wanted
can,
to.
yeah, he can, but he's already in jail, he already said.
I can make a finding that something's going on, and if I find it dangerous, I can watch it.
Well, I also said to the councils, I said, you don't want to proceed with the hearing, obviously we can't proceed today because he doesn't have, he's just in a ring. I wanted to set this for a hearing. If he doesn't want to proceed with the hearing, I said, well, that's fine. Then you can stipulate to him being in jail and then maybe incarcerated until that case is resolved. He doesn't want to do that for obvious reasons.
I understand what you're finding, and potentially have been watched.
I mean, this is someone living his guidelines. No, you weren't. At 17, you were very unhappy with us. You almost didn't take it. Yes.
Unfortunately, I can speak necessarily to what happened previously.
I mean, the whole purpose was. Okay, thank you.
Had I arraigned him on this? Or no?
I
No?
believe today would be.
Today it is, okay, great. This is docket 2496
Oh, I think
FH.
they're getting
Is he in lockup?
Yes.
Okay,
Yes.
thank you. This is docket 2496 FH, people of the state of Michigan versus Nathan Wayne Carper. Counsel, your appearance for the record.
Andrea McCray, on behalf of the people.
Assistant Public Defender James Harris here on behalf of Mr. Carper for the arraignment. Mr. Carper is standing to my right. Mr. Carper, if you could please state your first and last name for the record.
Nathan Carver.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you were placed on probation. You pled guilty to criminal sexual conduct, assault with intent to commit sexual penetration with habitual third. That's punishable by 20 years. You recall that?
Yes, ma'am.
There was a plea agreement, which I was not happy with at the time, but nonetheless, I honored it, and it was a Killebrew agreement for no further upfront jail. And you were placed on the 60 months probation. And that was subject to not violating law and a whole lot of other things that you were supposed to do. So I have two allegations here that I need to advise you of, which is why you are arrested and in that jumpsuit. And it says count 1, on or about March 31st, 2026, defendant threatened and intimidated Anita Pico, P-I-C-C-O. Count 2, on or about March 31st, 2026, defendant communicated threats toward Anita Pico, who is his former spouse. The concern with this would be that you were not to assault or otherwise commit a crime against anyone that was part of the probation conditions. And so, and not to have any assaultive behavior, that would be physical and verbal. So there's these allegations against you. So I understand that this allegedly occurred in another state. So I want to make sure you understand as we go forward with this, that you have an absolute right to not testify if we go into hearing. Do you understand that? You have a right to a hearing. The hearing is by preponderance of the evidence. It's the people's burden to prove. You don't have to do anything at all. And you can cross-examine any witnesses and evidence brought against you. You can also choose to bring witnesses and evidence in your defense. Any witnesses the court would order to be present. And the people could cross-examine any witnesses and evidence you have. You could also choose to testify or not testify. However, I just want to caution you, and you have a good attorney who I'm sure will advise you further, but anything you say or write can be used against you. And if there's pending charges, this will all be under oath. So anything you say could be used in whatever case there is. It's not pending in Michigan. I don't know much about it, but counsel just advised me that there are either likely charges or pending charges. I'm not quite sure. But anyways, counsel, you're waiving further arraignment.
Yes, Your Honor.
And will this be a plea or a hearing?
At this time, my understanding is the prosecution is requesting a hearing, and the defense would be, well, the defense would not be entering a plea at this time, Your Honor.
And you are requesting a hearing?
I am, Your Honor. I spoke with the victim from the Indiana case just about an hour ago. I am requesting that hearing. I've received the entire case file, including the text messages. So I'm absolutely requesting a hearing. I'd also like to address bond.
All right, so are you prepared to go into hearing today, or counsel, do you need time to prepare?
The defense would request time to prepare, Your Honor. My office has, my understanding is, sent an appearance in regarding the probation violation, which is why I'm here today. However, I have not received any of the evidence regarding the alleged violation that would be potentially testified to or have a hearing held over. Additionally, I would request if the court is going to set a hearing, I request the court potentially that has set that hearing out, so we can at least have perhaps some more information regarding the court in Indiana regarding how this is going to proceed.
Are there pending charges against you in Indiana, sir?
Yes, it's a felony 6 intimidation.
Okay,
Okay. Yep, that's
all right. So on behalf of people, the evidence that you have you shared that with defense counsel?
So his appearance wasn't in my file when I came down to court this morning, but I'm happy to, our discovery unit gets mad at me if I just forward emails, but I'm happy, I will make sure he gets everything by the end of today. Hope with the caveat that we have that appearance just because our office requires that.
How much time do you need to prepare for hearing?
I would request, I guess, at least 30 days, Your Honor, given that I would need to check in with my office as I do note I normally am not handling felony cases or potential probation violations on felony cases.
Your Honor, I'm fine if we want to set this a few months out, so long as the defendant remains in custody due to his danger to the community.
And
All right, further, sir, you had David Carter as your attorney. Are you going to retain him? Or
For
would you
this?
like me to appoint you an attorney?
I actually hired an attorney down in Indiana.
Okay. But he's an Indiana lawyer or a Michigan?
Yeah, for Indiana.
Okay,
So
so he could talk with whatever lawyer you have here, or he could be waived in. I don't know if you want to pay him to come to Michigan. But I guess he could appear on Zoom, but I don't know what your status is here. Would you like me to appoint you an attorney, or do you want to contact Mr. Carter?
if you could appoint me one, I'd be
Okay, I'm
helpful.
gonna appoint you one through the public defender's office, and so you decide if you handle it or if someone in your
Understood.
office does. And I know my schedule is very, very tight, so whether it's in 2 or 3 weeks, I do not know. But I'm gonna ask you all to go back and get a date sufficient enough for defense to prepare and counsel to be appointed, and so you all can exchange information. As to bond, on behalf of the people, what would you like me to know?
Thank you, Your Honor. This defendant was sentenced in early February. Less than 2 months later, he picks up this new allegation. The allegation is that he threatened his ex-wife and mother of his 2 children. And what the specific allegation is, he called her a quote delusional cunt. And then said, go ahead and block me. Just a friendly reminder, no one is getting out of here alive. This is very consistent with the defendant's history of treating women, quite frankly, like trash. In her further statement, the victim said, my ex-husband, Nathan Carper, has always been a violent man. I could give many examples that have caused fear for many years. History of abuse, sexual assault, and death threats. The most recent threat happened this morning, and that was March 31st, 2026. I was awoken to my phone blowing up with messages calling me names for blocking him on all messenger with a final message saying, as I read earlier, about no one is getting out of here alive. He has often used violence and death threats to control me and my sons. I keep our address a secret for our own safety. We have those text messages, Your Honor, as well. The defendant, even in his jail calls from May 8th, said that he doesn't even deny that he sent this. He says that they were cropped, and so there's some explanation, I guess, for it, which is fascinating. If Your Honor will recall, back on this case, I had filed an other acts motion detailing his history with women for several years, including a 2021 case of felonious assault. He was actually on probation for that case when he picked up this rape case here. And what happened in that case is that he held the victim hostage for more than 3 hours. He said he would slit her throat if she tried to leave. He said, I'm going to kill you, bitch. He slammed her head into the bed, punched her head 6 to 7 times, and threw a large board with nails at her. And he pled guilty to felonious assault on April 25th, 2023. He had the other acts motion I brought to this court was an incident that happened on February 21st, 2018 with his ex-wife, Melissa Carper, who is different from this other ex-wife for this new case, where he threatened her cat with a shotgun, saying to her, it's either the cat or it's you. So, Your Honor, that's 2 other instances that it comports exactly with the kind of behavior we're seeing here again. I would point to another incident, because he did another other acts motion for one of his female friends. I believe her name was Karen Jones, and how she discussed how he stalked her, terrorized her, and that he, to the point of her needing to fire a shotgun at him to protect herself and her home. He has a long criminal history. He just can't stay out of trouble, quite frankly. He's a danger to the community, and more seriously, he's a danger to women. The way he treats women is disgusting. He is terrible to women. And Your Honor, at sentencing, you said you are out of jail time, sir. You're out of jail time. This is a gift. This is a gift. You could be going to prison right now. You have spent 700 days in jail. And what does he do? He laughs in the court's face, and less than 2 months later is sending his ex-wife and mother of his children, calling her a delusional cunt and giving her death threats. That is not someone that is accepting of a probation sentence. This is someone who is not going to change his behavior. He has shown us exactly who he is, even when we gave him the opportunity to do everything right. He was given a gift. He laughed in our faces, and now it's time for him to be in prison where he belongs. So I think he needs to be absolutely remain in custody, because that's the only place the community is safe.
Your Honor, can I speak, please?
Well, your attorney, I hear him, is
Yep.
vehemently saying not to say anything. So before you decide to speak, sir, let's have your attorney talk, and then we'll have a chat about that. Counsel response.
No, sir. Regarding this, Your Honor, regarding any instances of past acts, I can't necessarily speak to those. Regarding the alleged violations that bring us here today, I would indicate that as serious as they are or can be, they are allegations for which, at least currently, he maintains the presumption of innocence until he either enters a plea or is found guilty. I would simply ask if the court would consider setting some kind of bond, something that he can potentially be able to post so that he can try and get the case in Indiana resolved, Your Honor. Thank you.
Sir, anything you say or write can be used against you. If you think that Indiana is stupid and they won't look to what Michigan is doing, you are wrong. There are compacts between courts and states, and we exchange information all the time. Law enforcement communicates regardless of whether it's a local sheriff or the FBI or state police. There's communication between prosecutors. So be very, very careful, because the one who steps on your rights isn't going to be me, it's going to be you. So if you say something that impedes or affects the other case, that's on you. So I would probably, if I were your counsel, echo what your attorney has said, but just as a reminder from the bench, it's your life, it's your decision. And if you want to say something that potentially affects the other case, that's on you. What's your choice, sir? You want to remain silent, or would you like me to know something? And if you do want to talk, you probably don't want to talk about that other case.
Your Honor, I would just like a chance to I would like a reasonable bond, at least have the chance to go down there and fight with the evidence that I have on my phone that I've already hired and discussed with an attorney, that I feel more than confident getting resolved in my favor.
Okay, well, we have extradition, and I suppose I could release you to that other state. There's ways that we handle cases, but sir, here's the problem as I see it. Every single day, and I've paid close attention recently because it's just been shocking to me, because we have so many guns in our own community. But every single day in the United States, some parent has taken it upon themselves to take a gun and kill their other spouse or their children and then kill themselves every single day. When I look at your history here, you escalated to criminal sexual conduct, but when I look at this history, you have juvenile history. A lot of juveniles have that. So even if I don't look at those things, when we get to the adult history, we have very serious offenses: assault and battery, operating while impaired, assault and battery, misdemeanor animal abandoning / cruelty to one animal, misdemeanor intimidation, operating while intoxicated, unlawful imprisonment, and felony assault with a dangerous weapon. Those were charges at arrest. Final charge was assault with a dangerous weapon. We then have misdemeanor carrying a handgun without a license. And then the final charges, resisting law enforcement. And then we end up with this criminal sexual conduct case that's in front of me. And now, while on probation, which was meant to rehabilitate you after you spent 706 days in jail, I end up with allegations that are very serious against a spouse where you have children with that spouse, sons, as I understand it. And you are saying no one's getting out of here alive.
Your Honor, I was in communication.
Sir.
with them. Oh, sorry.
Not saying anything.
Yeah,
Could
I'm
be-
sorry.
No one is getting out of here alive is a clear death threat. You have a history with guns. You have a history of violence. There is no bond until I have this hearing, and if you want to constitutionally, I guess I can give you a bond, $1 million. How's that? Until we have a hearing, and then you can change my mind, and you can have a bond report, and we can look and see what's going on with the other case. So let's make it $1 million. That's what, I could make it $1 zillion. You can't probably pay the $1 million, but I think your children's lives and your ex-wife's lives are important. And so is yours, by the way, sir. This behavior has to stop. That's why you were put on probation for 5 years. 2 months you violate, I have serious problems with that. So while there's a presumption of innocence in your other case, there's also a reason that I can hold you, and that is public safety, safety of others, whether they're in this state or any other. I don't care. We have a history of violence against women, and I certainly don't want you to be another headline. So please get a date and set this for a hearing, and then we will, yeah, so here you go, just so I don't end up having to deal with, he's entitled to a bond because of the seriousness and the danger and the history here. It's gonna be 1 million cash with the GPS tether. No contact with any victim, no weapons. And of course, the rest of the probation terms that are already in place. I believe, sir, I gave you an adequate warning at the time I sentenced you. And I am actually rather shocked that I am here, especially after you had over 700 days in jail and assured me this would not happen again. So there is a presumption of innocence. I am erring on the side of public safety. On behalf of the people, you'll get a date.
Yes, Your Honor. I don't know if Mr. Harris wants to first reach out to the defendant's counsel in Indiana to see, because we might get a better idea of dates if, you know, I don't know if they know, they have a better
You
time.
have until next, sorry to interrupt, you have until next Friday to get me a date, or else I pick one and I'll cancel your plans.
Sure.
So we have 1 week to get a date.
And, Your Honor, if I may,
Yes.
my understanding from Mr. Carper here is that the next hearing in that case in Indiana is that they've indicated June 8th.
Yes.
Great. Well, you all figure it out. We'll figure out this hearing.
Understood, Your Honor.
So no contact with any victim in any state and, or any witness. No contact means no contact, sir. That means no telephone contact, no skywriting, smoke signals. Do not use somebody else's card in the jail to call your ex-wife. Tell me about, what are the ages of your children?
They're 17 and 18, Your Honor.
All right, well, do you have contact with them?
I do,
Do
actually.
you have, do they have separate cell phone numbers?
my oldest son has gotten into some trouble. I was actually sending him money, helping him, because he ended up in jail.
Okay.
And that's what this whole argument started.
Sure, don't talk about the case, and here's the thing, if your child's in trouble, you work with the spouse, the ex-spouse, you don't do whatever this is, it doesn't, there is no shock to me that your child is in trouble when he's grown up with a man who has 12 felonies. Come on, sir, what?
In those messages I was saying.
Sir.
Yep, sorry.
Again, I'm not the trier of fact, I'm not the judge in that case, but you're going to hurt your case because anything you say or write can be used against you. So, if, I don't know what's going on with your kids, as long as you don't send messages through them, you can have contact with them, if that's allowed. I don't know what's going on in that state, and I don't sit in the family court there. So if it's allowed, he can have contact with his children, but not send messages, since they're basically, one's an adult and the other one's almost an adult. So if they have cell phones, you can certainly call them, you can write them, but not any, unless they're witnesses to this. If they are witnesses, you cannot talk to them. So does that make any sense to you, sir?
Yes.
Great. I'll look for a date within a week, or else I'll set it myself. I'll see you soon, sir. Thank you. It's all for the record. Next matter.
I'm gonna handle Mark Mitchell next, Your Honor.
This is he coming? Is he here?
He's in custody, Your Honor.
Custody,
Yes, he's in custody.
Always nice to see you, Andrea.
What was that, Judge? I'm sorry.
I said it's always nice to see you.
I know, we have so much fun. Such a fun time here.
All right, this is docket 251969 FH, People of the State of Michigan versus Brian Thomas Jackson. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Barbucks on behalf of the people of the state of Michigan.
Your Honor, this is Mr. Mark Mitchell.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
You
ma'am.
may put your hand down.
Your Honor, if I may, I just wanted to confirm because I believe you said Ryan Jackson when you were
Oh,
covering the
did-
case.
Oh, you know what? I'm sorry. I read the wrong, this is Mark Anthony Mitchell, sorry.
Yes, and.
So sorry. I was reading the wrong,
and
so
apologies,
anyways, yes.
Your Honor.
Sorry about that. Counsel?
Assistant Public Defender James Harris,
Okay.
here from the Ingham County Public Defender's Office on behalf of Mr. Mitchell for purposes of the arraignment.
Thank you. Yeah, been a long day. Thank you for that. All right, so sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had an opportunity to speak with your attorney?
Yes, I have.
You're satisfied with his representation?
Yes, I am.
You're ready for me to read you the allegations that brought you before this court in that jumpsuit?
That's right.
All right, so you pled guilty to count 1 retail fraud first degree. You were placed on probation. And this says, this bench warrant that was signed by the court on January 23rd, 2026, says that on or about January 13, 2026, defendant failed to report to probation department or any time after that. And on behalf of probation, are there any amendments?
No, Your Honor.
All right, and for the record, did you state your name?
No, Your Honor. I'm AJ Gale in probation.
And counsel, are those the allegations you've discussed with your client?
Yes, Your
Are
Honor.
you waiving further arraignment?
Yes, Your
Will
Honor.
there be a plea or a hearing?
My understanding from speaking with Mr. Mitchell is that he is going to be admitting to the violation.
Is that correct?
Yes, ma'am.
All right, sir. For failure to report to probation department on or about January 13, 2026, and any time thereafter, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No, Your Honor.
You pled of your own free will?
Yes, I have.
And no one promised you anything?
That's correct.
All right, and sir, you understood, I sentenced you September 24th, 2025, and we talked about probation and that you needed to report each and every time you were told, and it would likely be monthly, and you stopped reporting. Is that all true? Were you, well, first of all, it's true you failed to report.
Yes,
right?
it is.
Okay, so you knew you were supposed to report, right?
Yes.
Were you hospitalized, incarcerated, in a coma, or what? Why didn't you report?
I got overwhelmed.
With what?
Everything.
Well, tell me about that.
I came before you last year, and this was during your Dietrich Park situation. And in fact, I spoke at your court.
Mhm.
And at the time, I was working, doing construction.
Mhm,
In Rise,
mhm.
and I was trying to get my peer recovery coach certification, seeking safety certifications, which I ended up getting both of those.
Okay,
And so I took on a second job
okay,
with the Eastside Community Action Center, where I helped start a program called Adam's House.
okay.
And working with my team, with Agent Bain and the team that you had, Nate, my peer recovery coach, I had a lot of good people working with me. But it was just so much overwhelming stuff. I ended up getting partial custody of my granddaughter, and then she gets taken from me,
Why is that?
felon on probation,
Okay, so where is she?
back with her mom.
Okay, is that a good situation?
No,
How old is she?
3.
Okay,
I go through that. The girl that I'm with at the time, she gets diagnosed with cancer. I got to sit in hospice and watch her dwindle and die.
okay.
I go see my probation officer the last time, and it's just, everything just crashed at one time.
Sir, you know where I am. You just come and tell me. You tell probation, we can help you. Let me just turn to probation for a minute. Did he complete anything, or is there any money that's owed, or what?
Your Honor, from what I understand from Agent Bean, he was working really well through recovery. He had a few more sessions with Eastside before, and he had absconded like 20 days before he could have been discharged.
Okay, so how many days jail does he have now?
He has 31 days, Your Honor.
I believe if I may, Your Honor, I believe he had, according to the PSI, he had 31 originally, and it has been, and now he's been in jail since the 8th, so I think that might have actually put it up to about 37 or 38.
All right. Would you agree with that, Ms. Gale?
Yes, I would, Your Honor.
All right. Anybody else want to address the court? Because I'm going to make my ruling.
No, Your Honor.
Great. Sir, you get 38 days of credit for 38 days, successful discharge from probation. Go out and do great things in the world. We're done. You still want to say anything?
Coming back to see you,
All right.
and I'll have the suit on next time.
All right. I appreciate that, sir.
Thank you, Your Honor.
Thank you.
Are you tirade Stuckey next, Your Honor?
All right. This is docket 253479 FH, People of the State of Michigan versus Tyrance Lamar Stuckey. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Stuckey. Mr. Stuckey is present, stands to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth that becomes perjury?
I do.
Thank you. Put your hand down. And sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on? Any sign of fever, COVID, or other illness? And you had enough time to talk with your attorney and review the pre-sentence investigation report? All right, can you speak up a little bit, okay?
Yes, ma'am.
All right, very good. And sir, you pled guilty to count 4 aggravated assault of 1 year I'm sorry, you didn't plead guilty. You pled no contest to aggravated assault of 1 year misdemeanor. Do you recall that?
Yes, ma'am.
All right. On behalf of the people, any corrections, additions, deletions?
The only change, Your Honor, is the sentencing date. The sentencing date is currently on the PSI as 4/29. It needs to be 5/14.
No objection to that, Your Honor.
All right. I'm making that change throughout. Did we request a PSIR and a misdemeanor? I usually don't do that.
I believe you did, Your Honor.
Well, what I will say is I believe there was not a referral initially to probation. The court was going to, and then there wasn't one. And then the court changed its mind.
Oh,
And then
maybe because.
I think Free Trial Services or somebody got a hold of Mr. Stuckey.
He told me just go down there anyway, and
Okay,
Yeah.
so I just been doing
Alright.
everything I've been told to do.
but that's good. We like that. So I've changed the date all the way through. We have a victim here? Or are there any corrections, additions, deletions on anything
Oh,
other than the date throughout?
the defense did have some things that we talked at a previous court date about, Mr. Buxton.
I'm sure we did, but it was a while, so.
That's fair.
Okay.
Hopefully it will jog your memory here in a moment. We had, Mr. Stuckey indicated that he had some corrections with regard to the 2, I believe, out-of-state convictions from Ohio that are reflected. And we wanted to at least make a record of those
Okay.
objections.
What are those? Where are they?
Those would be on page 5 under criminal justice, adult history. That's
Yes, I see 5.
Okay. It'd be,
Well.
section
Oh,
4.
Correct, I believe it was 1 and 2.
Yes, charges 1 and 2, pardon me.
okay, because that's where I see, the Cleveland Police Department,
Yes.
1 and 2 of 15. Okay.
Yes.
So what needs to be changed?
Yes, Your Honor, with regard to the number 1 of 15, Mr. Stuckey indicated that that was that put down for misdemeanor, or was that just?
So originally it was possession of cocaine. Was it pled down to, then it was attempt drug abuse was the plea and 2 years probation.
Yes, Your Honor, and
Is
That was
the
the
attempt
misdemeanor?
the misdemeanor?
yes, it would have been a misdemeanor, it would not have been a felony, Your Honor, and I don't believe Mr. Buxton was able to figure out anything to do.
That is correct. I did look into that one. I tried to figure out if that was a felony that was brought down to a misdemeanor due to being an
It
attempt.
looks like it.
And I could not figure that out, Your Honor, based off of my review of the Ohio laws. So
Okay.
the people, if the
I'm just
people would
gonna
have no
put
objection.
misdemeanor. Yeah, for this purpose, it's not gonna have any, I
Yes.
have no reason to not believe him, and it's not gonna have any effect for this purpose, so
And I
I
would
made
agree.
it a misdemeanor.
All right.
Okay, what about the other one?
Number 2, he indicated, Mr. Stuckey has indicated that that ended up not, that was not a felony either, so,
That's the contract.
yes.
Yeah, I was never charged. I was never,
You can speak up if you wanna. if you're on
So
the-
you were charged with carrying a concealed.
I was charged but never convicted. That's what I'm
Okay,
trying to
it
say.
says attempt carrying concealed.
Correct.
There was a plea and 2 years probation, 18 months suspended confinement, you were given fines and
And
costs.
then they finally threw it out because the gun was rusty. It was I was just in somebody's car.
So they ended up dismissing it?
Yeah,
And Your Honor,
I never got charged with that.
I have his criminal history, and it does state that there was a conviction, so I'm not sure what's
Okay,
going
so
on.
on this, I'm simply going to write defendant.
I never did any jail time in my life, Your Honor.
Okay, you recommend fines and costs, so I don't dispute that. I just don't know how they entered it, so I'm going to put defendant disputes this.
Yes.
And believes it was ultimately dismissed. Sir, this is a misdemeanor for, this is not, but we're making a record of this, but ultimately it has no effect in terms of guidelines or anything. It's not gonna affect anything really, so, but I appreciate making that correction. Okay.
And those were the only matters that Mr. Stuckey wanted to bring to the court's attention and make a record of. Thank you.
All right, thank you. And is there a victim who is going to address the court?
I'm not sure, Your Honor. Is Cara Gonzalez present? No, Your Honor.
All right, on behalf of the people?
Yes, Your Honor. I would ask that you follow the recommendation of probation. Given the charges as they were, this was a pretty serious offense, Your Honor. However, I do believe that probation is appropriate given the situation. Reading through the victim impact statement and reading through the offense narrative, Your Honor, it appears that the defendant was on drugs. She believes that the victim believes that he was on methamphetamine at the time and would stay awake for hours at a time and has a history of substance abuse. So I believe, Your Honor, that there should be some type of drug testing as part of probation.
Thank you.
Thank you, Your Honor. As the record does reflect, Mr. Stuckey pled no contest. He disputes the allegation. He's always disputed the allegation regarding drugs being an issue for him in this matter. The reason for the no contest plea had to do with civil liability. It did not have to do with a lack of memory and intoxication. I would note that Mr. Stuckey did spend a significant amount of time in custody on this case, and the corresponding case that was dismissed as part of the plea agreement in this matter. He has, to my knowledge, had no violations of his bond while awaiting the outcome of this case when he was released in September, correct?
Correct.
All right. And he did participate in programming while being in county jail. Ultimately, Your Honor, the agreement here was for something with some kind of probation. I would ask the court for a short term of probation if that is what the court is inclined to do. And to allow Mr. Stuckey to continue doing what he's supposed to be doing in the community. He is employed now, correct?
No, I can't.
That's right, disability because of your.
But my going back and forth to doctors, my
I can.
surgeries.
All right, give me a second and I will let you have a moment, the court will. He has surgeries and things that he is having to do. I'd ask the court to just adopt the recommendations at this time and then I leave the rest to Mr. Stuckey. Thank you.
Sir, what would you like me to know?
Your Honor, like I said, I agreed to the deal. But the only thing I would just like you to know is that from the very beginning, and I'm gonna make it short, from the very beginning, I've listened to this case, I've listened to the prosecutor. The officers came to my house 3 days after this report was made, and I never been asked any questions. I just was made guilty. And I don't feel that was fair to me at all. They just came to my house from what was said, and then we went through all of this, and I've been doing everything I've been told to do. My life has been miserable. The 6 months I spent in jail and my home was left, she destroyed my home. Destroyed my automobile.
Are you married to her?
I was common law. We lived together for 20 years.
Were
And
you
this is
married?
what, pardon me?
Were you married?
Never married.
You have children with her?
Yes, 4.
How old are they?
Ranging from the age of 20 down to 13-year-old twins. I've always taken care of my kids from day one. I've never had a problem with her. This was inspired to her through her sister. This is what I'm saying. This is a bigger case than what we all have heard, but I just let it go. I did my time and I'm just asking, please, I don't need no probation. I don't bother her. She came, she spoke on my behalf. She told you she's not afraid of me. I just need this to go away so I can continue my life and try to get it back in order like it was before I went to jail. I'm on disability. I'm in the hole so far. I'm trying to go to agencies to get help.
Where are you living, sir?
I own my own home, 1326 Rio Road,
And where is she living?
somewhere, not with me. I don't know her address.
And
He
where
told
do your
me
children live?
with her.
So you don't know where your children are either?
I know they with their mom. I have contact with my kids through their auntie. That was the court's, that's what the court asked. I don't bother their mom. She don't bother me. After 20 years, and it hurts, but I don't. That's what the court said do. But I completed all the classes. I've been doing everything, and I'd just like for this to just end today. I've been coming back and forth to court, not being seen, and I'm still coming. I don't have money to just keep all this riffraff.
Is your name on the birth certificate of your children?
Yes,
Have you ever gone through the court for parenting time?
parenting time.
Yes, or have you just always been in their lives?
I've always been in their lives.
So what's going to happen now in regard to your visitation with the children who are in her care?
Nothing. They come spend every weekend there at my house.
So.
Till school get out, and once school is out, I'm quite sure they're gonna be there more frequently. But right now, they're in school. They go to school in Lanesburg. She drives them back and forth every day.
Okay, sir, 15 times you've been in front of a judge.
Yes, ma'am.
Okay. And you know that you're not supposed to have weapons, and yet you had weapons. And those have been forfeited. I know you haven't pled to those. You pled to the aggravated assault, right? But her victim impact statement says that you had put a gun in her face.
Can I speak, please?
Just a minute. And I am very concerned about your behavior that she indicates with the white powder, how you appear to be on drugs. You told her, don't you dare go in there. And then pointing to the bedroom door, and she said, okay. And you said, you think it's funny, bitch, pulled a black handgun from the front side of your waistband and aimed it directly at her face. She said, that's not funny. And then you said, that's what I thought. You placed it back in your waistband. So that behavior is concerning. We got deaths everywhere with families.
But Your Honor, can I just please speak now? I listened to what you just read to me, but my kids was in the home when this went on. And I'm not getting loud, but what I'm saying is my kids was in the home when this went on. They came and spoke to my kids. My kids never mentioned anything. All of this was made up. I've never was questioned from the beginning. It was just what she said, so I gotta accept that. It's not fair to me.
Sir, then we have a situation here where you shouldn't have pled no contest. We should be going to trial, prove your case, or have the people.
I tried doing
You don't have
that.
to prove anything. Now you're trying to prove the opposite of what you pled to.
No, the prosecutor couldn't get a hold of her. She wasn't cooperating.
Sir, the prosecutor,
whatever.
stop. The prosecutor doesn't have to cooperate. They brought these charges.
I understand, and I thought when I pleaded to this, that, you know, I've been doing everything, I've been doing everything right. I accepted what she said and did. It's done, it's a done deal.
What you got, what brought you here, let me start with that. What brought you here was doing everything wrong, okay? The plea deal was an amazing plea deal considering the original charges were assault with a dangerous weapon, felonious assault, which is a 4-year felony, domestic violence, and weapons felony firearm, which the prosecutor in this county rarely gives that one up. That's 2 years consecutive within preceding any term of sentence. So you got a heck of a deal here, sir, and you're telling me you didn't do any of it.
I'm confused.
Sir, what I'm telling you is they dismissed that. So whatever your attorney did when they had a conversation with the prosecutor, they did right by you, considering what I'm hearing you say. You wanted to fight the gun charges. Well, apparently you did, because you got a 1-year misdemeanor, which rarely ever happens. But now you're telling me you've done everything right, and so you want me to just dismiss this and you go on with your life. Well, sir.
I'm not saying that, Your Honor. I'm saying throughout the course of me being in jail and the classes and all the stuff that I've been taking and doing, that's not enough yet?
Sir, I don't know what you've been taking or doing. I need to make sure that for a period of time, we watch you. For a period of time, I make sure you're not using drugs, you're showing up, and you are acting appropriately, because we have a community here that doesn't need any more violence. And I see that you're very agitated. That doesn't make me happy.
No, what I'm
That tells me
saying,
you need some probation. What are you saying, sir? You got a deal of no upfront jail. And it says defendant agrees to term of probation. So where's the term of probation you agreed to? That wasn't my agreement. That was your agreement. Counsel?
Yes, Your Honor. What I will note for Mr. Stuckey's desire is that he indicated that he did hire an attorney, I believe it was Fred Blackman, with regard to the Ohio case to try to figure out the gun rights situation.
I don't care about that one.
I understand.
We've got these charges right here that our prosecutor has a zero tolerance. So John DeWayne, for whatever reason, said, I'm not gonna pursue that against this guy. You got your deal there, but your deal included a term of probation, and now you're telling me you don't want that probation.
no, I'm not saying that I don't want that probation, Your Honor. I thought once I was released out of jail, you let me out on test, you removed them for my medical issues. And I've been reporting to my probation officer since I've been gone.
That's
I haven't been
fine.
doing any drugs or anything. I'm not a drug addict. I'm not an alcoholic. I don't drink. I have medical problems.
Okay.
I'm sick most of the time.
Okay, I'm sorry about that, sir, but your deal was that you get a
Yes,
short
ma'am.
term of probation.
Yes, ma'am.
And that's where we're headed, unless you'd like to do some more jail, or you want to do a longer stint of
I can't do
probation.
any more jail, Your Honor. I'm about to lose
Okay.
my house. I'm just trying to keep my life.
Then what are we
It's been-
arguing about, sir? I'm not happy about this. And you need to acknowledge that, you cannot be with the woman that you've been with, even if she wants to be with you. You two are like oil and water for whatever reason. This is a horrible situation, and your kids should not have been part of that.
I
Stop.
100 believe what you're saying is
All
right.
right, go, you know what? The world is filled with women. Find one you get along with.
I don't have a woman. I'm at home alone. She was in my home, Your Honor. This is what I'm saying.
Okay,
It's
go
my.
let her in.
If I may, Your Honor.
You may.
Thank you. I will also note that Mr. Stuckey did, it appears, complete several of the classes for MRT while in the Ingham County Jail. I do have that in front of me. I can forward that to the prosecutor court. So I do, as well as probation, so they know he has completed already.
All right, so he's gonna be on probation for 6 months. He shall not use, possess, consume, purchase any alcohol, illegal drugs, or drug paraphernalia. He will submit to any drug or alcohol testing if probation believes that he is using. He'll not adulterate any tests. If he's positive, he'll pay for a secondary test. If he's not positive, then he doesn't have anything to worry about. He'll not have any verbal, written, electronic, or physical contact with Kara Gonzalez, the victim here, and so the contact with his children will be through what appears to have been working the aunt or other relative, and he will not talk about this case with his children. He will not engage in any assaultive, abusive, threatening, or intimidating behavior. He will have 365 days jail with credit for 186, and the balance of that jail is held. He'll comply with all written and verbal orders of all treatment providers and probation, and allow probation into his residence at any time for probation supervision without a warrant, if there's reasonable cause to believe he has items that may violate the conditions of his probation, and that's for vehicle, cell, residence, and computer. He must report any arrest or police contact, personal protection order, loss of employment, or change of residence to probation within 24 hours. Weekends and holidays are accepted. And he will pay a $75 crime victims and a $50 state cost, that's $125. I'm waiving probation oversight costs. He will not have any objects as sir, be quiet. You will not use any object as a weapon. You will not own, use, possess, or have in your presence any weapon, ammunition, imitation of a weapon. You'll not use any object as a weapon. If you need anything with marijuana or alcohol, then you will present a prescription from a licensed medical physician and use it as prescribed only. The $125, I understand you're on SSI, you've got medical conditions and everything else, the $125 will not, if that's due and owing and not able to be paid, I can't forgive it, but the state can get it whenever. We're not going to hold open probation if that is not paid and there's no probation oversight fees. If he can show to probation his completion of cognitive behavioral and anger management, then he will not have to comply with that. Otherwise, he'll have to do those things. He has 42 days to appeal and to request appellate counsel. Your counsel?
Your Honor, while looking over the PSI while you were reading your sentence, I did miss one other thing.
What?
It does state that the charge he pled to is aggravated assault. It's actually aggravated domestic violence.
Oh, okay. Yeah,
So it doesn't change the overall.
Yeah, I'm gonna correct that, and so it's aggravated DB, which is still the 1 year, it doesn't change anything else.
Correct.
Doesn't change what I'm doing. So let's get it right. I'm gonna go back into the instant offense and make sure that's correct.
So it's kind of correct in the evaluation and plan, Your Honor. It says count 4 domestic aggravated assault and battery.
Yeah.
So
It's okay.
I think that's fine.
Okay. Do you acknowledge receiving your appellate rights, sir?
Sorry.
Just keep checking in with probation, do the right things, and this will be over soon.
Yes, ma'am.
Your Honor, in regards to the other file, the 25-3159 FH, I just emailed the Denali to your court staff.
Will be signed immediately. Thank you. That's all for the record. Go down and make him keep your appointment with probation.
You just gotta go, you're gonna. He'll have to go to LPD himself and see if he can do
I
that.
understand. I know he gotta do it himself. I'm just saying that, do she have to sign a summary release?
For what?
Or something? For Mr. Pryor to receive his weapon back.
The weapon, whoever owns the weapon, if they have it lawfully in their possession, they need to go show proof of that and they can get their weapon back.
Okay, that's all I needed to know. Thank you. Have a nice day, Your Honor.
Bless you, sir.
And I did hand a copy of the appellate right form to Mr. Stuckey, Your Honor.
I
Thank you.
didn't see that. I think you're trying to calm him down. You know, that anger got him his 6 months.
I was trying.
Yep.
Yeah. Mhm.
Just.
It's in there, 365 credit for 174, I think, but I don't. Okay.
And then you said that his contact with children just
Continue through his aunt or other relative, not through the victim.
or other relative.
186.
Credit?
Yeah.
You said it was credit cards around.
Next, Matt,
Our attorney is Smith, Your Honor.
are you okay, or did she break?
Teresa,
One okay, or did you break?
Oh, I'm good.
we've only got one
We only have one left, all right. Ms. Wanji, all right.
Good afternoon, Your Honor.
Good afternoon. This is docket 25-5998 FH, people of the state of Michigan versus Artrinius, Hassan Smith. Counsel, your appearance for the record.
Good morning, Your Honor, or good afternoon, Your Honor. APA Barb Bucks on behalf of the people of the state of Michigan.
Please don't make it morning. It's
I know.
Okay, thank you.
Good afternoon, Your Honor. When I get one, what's this? Because I don't know.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you had enough time to speak with your attorney?
Yes, ma'am.
And I don't know that you're gonna have, we're gonna ask you anything today. This is a motion to quash, I believe, or to strike the evidence, or for an evidentiary hearing. So let me hear from your counsel, and you may have a seat, sir. Counsel, if you could, from the podium, I appreciate it. Please proceed when you're ready.
You know, I think that at this time, both the prosecutor and I, we think that we need another hearing.
An evidentiary hearing?
Yes.
All right, if we want, we could have just done that without going on the record. All right. So I'll tell you, that sort of makes my day. It will probably ruin another day, but time-wise, I mean, always entertaining to hear what's going on in cases since I don't get police reports. But why don't I just send you both back to get a date for the evidentiary hearing? I'd give you one, but my docket's really congested, and then meanwhile, bond-to-bond conditions will continue. Do you understand that, sir? So we're gonna come back for a full-blown hearing, so I can hear from law enforcement and whoever else, but meanwhile, bond-to-bond conditions will continue. Is that all right with you?
Yes, ma'am.
Okay, go get a date. Thank you, that is all for today's.
Just real quick, it
or
may
what?
take a little longer for our hearing. We're still waiting for the transcripts in this matter.
That's, when were they requested?
So my understanding, I was not there at the preliminary examination. My understanding is that they were requested at the preliminary examination, according to talking
Which
with,
was when?
which was back in,
And I'll tell you why. It's because, and if you don't know this, the judges, we have reached an agreement that at 60 days, we're going to pull the transcripts from district court because we're not getting that.
the
Now-
exam was from October 10th of last year, Your Honor.
I need the, okay, this goes on our list. We're gonna put this on our list and get this, and if we don't have it in a couple of days, we're gonna yank it from them. We have collectively are telling the district court judges that, and then we're sending this over to the state court administrator's office. It's a huge problem. What judge was this?
This was Judge Ward, Your Honor. I have tried to contact Judge Ward's new clerk. I have not received a response back.
Okay, and counsel, you requested this October?
Yes, Your Honor.
Do you remember?
After the preliminary exam.
Okay, well, I'm sorry, at the preliminary exam, did you do it in writing or did they not do it that way?
Say it again.
Did you do that in writing or do they?
Yeah, they always give us a paper
Okay.
to sign
At
and
prelim, and you did it in writing, okay. Okay, thank you. We are keeping a list, so we need to know. And from now on, when it gets to be about 45 days, call them and see where it is, and then let us know so we can send them a letter. This is the fourth case within about 10 days that I've had to move because of a lack of a preliminary exam. It ruins your day and it ruins mine because the schedules we all have are pretty tight, and that's a problem. So they gotta stop doing that.
I would
So
agree
we
with
are
that.
working on resolving that, just so you know.
Thank you.
All right, so we're gonna make the chief judge know that. Thank you.